IP licensing, M&A, and collaboration agreements. So a little bit about our firm, right? So we are currently ranked in the top 10 of IP specialty firms by Vault Law. We're a tier 1 firm according to Best Lawyers. We're also a tier 1 firm according to US News. We're really an IP strategic partner for our clients. Anything from AI to transportation to industrial products. We have over 70 attorneys with technical backgrounds in addition to their legal expertise. We have obtained over 33,000 patents and more than 1,000 trademarks on behalf of our clients. And we're also key drivers with our clients in licensing agreements, mergers and acquisitions, and collaboration agreements. We really see ourselves as your business partner to meet your end goals in really obtaining a large market presence that is enforceable and protectable. Yeah, so our topics today, IP fundamentals, right? Learning the IP licensing fundamentals, learning the basics of intellectual property and how to effectively monetize your intellectual property through licensing agreements. M&A IP considerations, understanding the due diligence process and considerations in mergers and acquisition transactions. And then collaboration agreements, right? How can we work with others in mutual beneficial relationships to further our market presence? And with that, I will turn it over to Pooja.
Actually, I think you're going to turn it over to me to start out, David. So I was going to start talking about the IP licensing fundamentals. And thank you, David and Linda, for the introductions. It makes me sound a little bit older, but all good. So I do have extensive background in licensing and licensing programs. As Linda mentioned, I represented as an in-house attorney a multinational global company that had pretty strong licensing programs. And from an outside perspective, I've also represented smaller clients, regional clients. All the licensing programs and agreements, they're all so specific and uniquely tailored, depending upon what the business strategy is, what the footprint is, what the type of business. But the one commonality is doing your upfront work and understanding what your objectives are. And that is, the planning going into it is what we're going to talk about a little bit today, and what types of arrangements you're looking for. But it's really key before you start any of these programs to have a good understanding of what your end goals are, and what the business objectives are. So for the first slide, looking at kind of an overview. So licenses are, as an owner or or an inventor, you've got a portfolio of IP, whether it's patents, trademarks, copyrights, trade secrets. And for various reasons, you want to expand the reach of your IP, monetize your IP by granting usage rights to others. You're going to control, how that's used, but you're not selling your IP. You're still maintaining your own ownership rights, but leveraging your IP to the betterment of your business. In patents, for example, you could have a manufacturing method that you're going to license out to suppliers. Perhaps you have too much demand, but you want that you can't. There's too much capacity, or you don't have enough capacity in your own supplier network, and so you have to reach out to others. Well, you don't want them taking your processes and applying it for your competitors, and so there you want to set up a structured license agreement. Trademarks. If you want to enhance your brand, doing so through distributors. You want to provide licenses out to your trademarks, but control how those trademarks are being used. Copyrights, you may have for example, licensing music to a film producer. Trade secrets, that's a tricky one. Trade secrets are your recipe, your formula, your real secrets of your company. But for various reasons, you may need to allow another party to have access to your trade secrets. For example, if you need to set up a new manufacturer. And so the challenge with trade secret licenses is that once the trade secret is disclosed to the public, you've lost your trade secret forever and you're not going to get it back. And so, oftentimes you'll see in these license agreements for trade secrets a clean team set up, or there'll just be a few people within the other organization that have access to that trade secret so you can maintain control. David, you want to go and flip to the next slide? So, what are the benefits? I briefly mentioned expanding your market reach. If you're a regional company or business and don't have a huge footprint yet, but you've got a great portfolio of IP that you feel like is sitting on the shelf and not being monetized, maybe it's an opportunity to expand your market reach through licensing. You're generating passive revenue. You're not actually having to put the capital investment to broaden your business's footprint, but through the license holders, you're getting a revenue royalty or a license fee, and also you're going to have an opportunity to build strategic partnerships. And so, and we'll talk a little about that next, but that's a way of enhancing your business growth. Okay, go ahead, David. That's fine. So, collaborative partnership. So this is where you've got a piece, but you need another piece. So, for example, if you got a software, some software IP, but you've got an idea that I want to put this into an integrated hardware product, you may have to work out a partnership with this hardware company. Oftentimes, you'll see licenses going one way, or maybe even cross licenses, but it's a way to meet your business objectives through this licensing. Competitor cross licensing. Now you'll see this in pharmaceutical industry. I saw a lot of it in the oil field service industry, where all of the competitors have found a problem, and they'll all start working towards solving that problem at the same time. They may all come up with a little bit different solutions to that problem, but they're all going to be similarly directed, and they're all going to be filing for their own IP protection. And so what happens is you end up setting up all of these IP landmines and blocking IP that you are now unable to bring your products to market for the benefit of the public because you've got IP standing in the way. And so what you'll see is these cross licenses between companies to say, look, we see what your solution is, we see what our solution is. Maybe we need to work out something so that we can both bring our products to market without ending up in huge litigation and slowing down the opportunity to bring your solutions to market. Another instance of using IP is avoiding litigation. And this is often, whether it be a competitor or a non-competitor, where you've seen someone who's infringing your IP, and rather than marching down to the courthouse and filing a patent infringement lawsuit or a trademark lawsuit, you can work something out and avoid the time and resource expense of litigation. Because these litigation, particularly IP litigation, they can they can last years and years, and you're going to spend a lot of money. And if you could avoid it through a licensing, still generate some revenue, that's another use of your IP on the licensing front. Go ahead, David. So other models are out licensing, in licensing. So out licensing is perhaps you've got some IP that is applicable outside of your business area or your technical field, but that there's other technical fields that would benefit from the IP. And so rather than have your IP sit on the shelf, you can approach some of these oftentimes non-competitors. They may not even know who you are because they're in different business areas. approaching to say, look, we've got some intellectual property that you could benefit from, and offering up a license to that. And so it really doesn't impact your own internal business. You're not benefiting your competitors, but you're actually monetizing your IP outside of your own business area. In licensing is, if you've got some product development or some ideas that you may need someone else's IP to fully explore or accelerate to market, then looking for opportunities to approach others to acquire licenses to enhance your own business and product development. And all of these have revenue sharing models, whether they're fixed fees or royalties. That's all part of a standard license agreement. David, if you want to switch. All right, so there's exclusive licenses, there's non-exclusive licenses. A full exclusive license is actually providing a license to the licensee, and oftentimes excludes yourself from being able to practice. So you're giving all of the IP rights to another company. So you have to really be careful before doing that. Make sure that was indeed your intent. If it wasn't your intent, make sure you're carving out your own use rights before you give this full exclusivity. You also have to figure out, is this going to be an exclusivity geographically, by product, by industry, and make sure that you aren't doing something now today that you may come back in 3 or 4 years from now regret providing this full exclusivity because now your business has changed or your models change or your footprints changed and now you want to be practicing in this area or you want another license holder to be practicing in this area. So full exclusivity is it always seems to be the starting point, but it has a lot of drawbacks. David, if you can flip. The more typical is going to be the non-exclusive licensee, where you're giving multiple licensees rights. If you had a software library that you wanted to get lots of users out there, then you're going to be offering these non-exclusive licenses. In order to do that, you have to make sure that you haven't already encumbered your intellectual property with an exclusive license to someone else. And so, it's really the planning stage of your licenses, thinking about today versus 5 years versus 10 years out is really critical because you want to make sure that you've controlled what the current intent is, but what the end intent is for your licenses. David, yeah. So, and before you start any licensing program, it's really good to see, and Pooja will talk about this on the M&A side, but from an internal pre-licensing side, you have to make sure your IP is actually ready to be licensed. Do you have clean ownership? Have you got everything registered? Are your patent applications, are they already granted as patents? Do you have the right geographies covered? You have to do all of your upfront work to make sure that you really are ready to license, because the first thing that the potential target is going to do is they're going to do their own due diligence and say, wait a minute, you're trying to license something to me that you don't even have rights to right now, or you don't have full rights to, or we don't think you've registered it properly. So, and they're going to put clauses in the license agreement that say, look, if it's found that the patent owner doesn't have full rights, or it's not registered in this jurisdiction, then I'm going to stop paying royalties, or maybe I can start practicing. So it's really good to have your homework done up front and make sure that it is, whatever you're offering is indeed a good fit for your business model. David, go ahead. So the upfront due diligence, we've talked a little bit about having an NDA in place. Make sure that when you're approaching these targets, to the extent you're going to be talking about confidential information or giving away what you're offering, make sure that's protected with a non-disclosure agreement. And you want to, when I say defining key terms, I really don't even mean in the license agreement itself, although that'll come into play. But this is before you go into any negotiation or approaching a target, make sure you understand yourself what it is you're offering. What is the scope I'm offering? Is it a territory I'm offering? Is it exclusivity or non-exclusivity? Am I seeking a royalty? Making sure you yourself understand what you can offer, what you want to offer, and then select your licensees carefully. You want to make sure you're selecting partners and not potential competitors. There's going to be some licensees that are looking to explore business and pursue their business in line with your expectations. And then there's going to be other licensees that may say, look, we're going to take a license to this IP, but at the same time, we're going to start developing to get around this IP. And we're going to start taking advantage of what we've just learned through this initial, whether it be the market intelligence, et cetera. And they're looking constantly to expand and broaden out beyond your license. So it is important to do some due diligence and think about what are their plans. Are they planning on immediately beginning work to get around this license agreement itself? And with that, I will turn it over to Pooja to talk about some of these IP considerations in M&A.
Great, thanks, Tim. So why does IP matter in M&A? Well, really in any M&A transaction, I would say IP is often a key driver of value, even if it's not immediately obvious. Because think about why a company would want to acquire another. Is it to gain a new technology or a well-known brand? Is it market exclusivity? Well, all of those have pretty significant IP aspects intertwined in them. So a strong IP portfolio would give a buyer confidence that they're acquiring a long-term competitive advantage, not just some type of asset or current customer base. Also, a strong IP portfolio could contribute to higher valuations by ensuring some sort of long-term revenue potential that's in line with the buyer's business plan. However, on the flip side, unclear or poorly protected IP rights can be a red flag that can delay or even completely derail a deal. You want to make sure that the IP portfolio aligns with the buyer's specific current strategic goals and future roadmap in the acquisition process. And the role as having IP counsel would be to spot these issues before they become deal breakers. Regarding valuation and monetization of IP, that's always a little bit of a hot topic. When you're valuing a company, the IP is often where the real value lies, and people always want a dollar amount kind of associated with that IP, especially when it comes to tech or consumer products, life sciences. And so generally, we'd work with a third-party provider, and we'd look at three key aspects. The first would be market potential. That would be evaluating the current market demand and growth opportunities related to the specific IP in question. Second would be legal strength. Is the IP enforceable? And finally, commercial viability. And that would involve determining the IP's ability to generate revenue through licensing and royalty. So, for example, strong IP rights, especially those that could be licensed or used to even block competitors, could drive up a price pretty significantly. There are a lot of situations where strong IP due diligence could be beneficial and prudent. It's pretty crucial in many business contexts, and we've just listed three on the slide here. But it all comes down to the same reasons, because an investor or an acquirer will want to know what exactly are they getting, who owns it, are there any skeletons in the closet like encumbrances or co-owners, pending lawsuits, small controversies. Tim mentioned some jurisdictional issues and enforceability. All of these factors come into play because it's kind of like running a home inspection before you buy a house. You want to check the foundation and the wiring in the roof, and in this case, you're going to want to verify the ownership or validity rights, usage rights, and see how this potential IP would be able to impact your business. So in M&A, for example, we touched on some of this before, but the due diligence would ensure validity, chain of title, accuracy, and risk assessment. In licensing deals, you'd want to go over key terms to make sure you understood what you were getting and prevent future disputes. And in financing rounds, investors would rely on a thorough IP due diligence to evaluate assets, to related to funding decisions. In summary, probably good due diligence can add real leverage at the negotiating table, regardless of the specific situation where IP is involved. We've gone over some common themes of what that due diligence process looks like, but it's certainly a case-specific process. It's not necessarily just a check the box exercise, but it's one way to uncover risk and sometimes hidden value. Overall, sorry about that. Overall, the IP due diligence process would involve just a thorough evaluation of the IP assets before any major business decision, both on the selling and the acquisition side. It definitely would look into verification of ownership and chain of title. There are many times where inventorship is a little unclear. A company has changed names or merged with another company. You just want to make sure that the chain of title is very clear for all IP that's potentially in question, and it's better to get that cleaned up before you enter into any type of agreement. And finally, these types of activities kind of help identify risk early on. And more so than that, like once the risk is identified, it can help you prioritize what you want to fix before a transaction so that there's no surprises later on. The earlier that counsel is brought in, the more proactive we can be about cleaning up any issues in advance of speaking with potential buyers or acquirers. So this slide discusses some of the more common risks that we see during the due diligence process. The first is unclear ownership. I touched on that just a little bit before, but again, you could have co-inventors who haven't properly assigned an invention, a trademark that isn't registered, IP that isn't even in the right jurisdiction everywhere, and even has mixed ownership across jurisdictions. So that's pretty common. We also want to touch on encumbrances in the next slide. We'll get into that in a little bit more detail. Sometimes they're hidden encumbrances like prior license or open source software obligations, which can limit how a buyer can use or monetize IP. Sometimes there are expired IP, so you'd have a mix of IP that's enforceable and some that's not, and it's good to understand what the actual live portfolio looks like. And finally, some small controversies or pending litigations that could pose risk and significantly or insignificantly impact the IP's worth and usability. So this slide just goes into a little bit more details on the hidden encumbrances and prior licenses, just because they come up a little bit more often than you might expect. These can include exclusive field of use licenses, pre-existing research collaborations, or even obligations for government funding. And that can limit the options that a buyer or seller has with the IP in question. For software, open source compliance can create some exposure. Failing to meet these obligations might allow others to use code a little bit more freely than you might like or think. And so again, the job of the IP Council would be to flag these issues so that you can recognize, mitigate, or at least disclose them properly. And with that, I think it's David.
Trying to unmute my mic. Yes, so joint development and collaboration agreements. These are a great tool for problem solving within your company. A great example is I'm working with a client right now where they have a product, they have a specific design for their product. They have all the manufacturing steps on a small scale to manufacture this product, right? So they have the product, they have the manufacturing steps. However, they're struggling to fabricate this on a mass scale, right? So we can get this to the consumer's hand, right? And so to solve that problem, they're working with a supplier, right, that can mass produce this, right? However, there are IP implications that go along with this, right? They want to make sure they retain their IP rights, but they also want to make sure that the company is willing to collaborate with them. And so that's where these joint development agreements and collaboration agreements come in, because you want to secure your rights, but you also want to collaborate with others to solve problems that you might not be able to do internally um, within your company. But there are some key things to consider when going along this process, and we can be a great resource for you as you go about this process, right? So as we've said, this is these collaboration agreements. They really clarify the ownership of the innovations that go along with the collaboration agreements. And then they also ensure that we protect the technologies that were in place before the collaboration agreement, during the collaboration agreement, and even after the collaboration agreement. They also facilitate commercialization, right? Using that example, right, where we have this company that has a certain product, they have the initial understanding of the manufacturing process, but they need help scaling it, right? These help establish that smooth process to commercialization. Um, we're able to pool R&D resources. They also reduce IP disputes, right? In a strong collaboration agreement, right? The IP ownership, the IP aspects of the agreement are clearly established, such that we minimize any future conflicts or future disputes over intellectual property usage. So joint development agreements, right? As compared to a broader collaboration agreement, these are more technology, process, uh, IP, product focused, right? This is for a specific item, right? And these JDAs, as we like to call them, they clearly define the ownership rights and then the commercialization terms of the property that was created together through these types of agreements, right? So, for example, using this, scaling of this particular product, right? So if there was any IP that was generated from both of these companies working together, right? The set company and then the scaler, right? How are we going to define the ownership of these IP rights that were developed jointly, right? And we have the name joint development agreement because generally these are jointly owned as compared to collaboration agreements, which have some more licensing aspects associated with them. Yep. So collaboration agreements, these are broader partnerships. These are more like R&D agreements, sharing of development and marketing and resource sharing. They may cover development of commercialized products, any type of market entry strategies between the partners, right? In terms of like M&A, I would say, and licensing, these type of collaboration agreements really play well in certain terms of a merger or acquisition or any type of licensing agreement. Right. So key differences, right? So JDAs are more technologically focused, collaboration agreements more of a broader partnership. We'll talk about foreground IP, right? This foreground IP is IP that is generated jointly throughout the agreement. Depending on the scope of the JDA, sometimes we accomplish this via cross licensing, as Tim mentioned, but these are generally joint or sole ownership as relates to the foreground IP. And then for collaboration agreements is typically licensed. The licensing for these JDAs are often development focused, where the collaboration agreements are more commercialization focused. JDAs are very narrow to a specific technical scope, where collaboration agreements are more broad and strategic partnerships. So, right, so key considerations, right? This is your background. One of the really key considerations that we really get into the weeds with our clients on is background IP ownership, right? Are you protected before entering these JDAs and collaboration agreements, right? You want to ensure that you maintain your IP ownership of your proprietary technology, ensuring that your IP is covered for your current products, processes, your overall technology before you enter into these agreements are very critical. And then in these agreements, right, we also have to really hone in on the use of this background IP, right? Because we part of this is, right, both companies are sharing with each other their background technology. So we really need to make sure that it's defined. And generally, how we accomplish this is via licensing, right? So maybe you would offer uh, a license during the term of the agreement to ensure that your strategic partner, right, can collaborate with you, right? And then foreground IP management, right? This is all the IP that was developed jointly from the agreement, right? Understanding on how we're going to parse that out. And then we also mentioned licensing rights and cross licensing. And then another key uh, item, and Pooja and Tim both mentioned this, right, is ensuring that we have proper safeguards in place as it comes to trade secrets and any other confidential information, right? And this really goes into the control of the disclosures, right? How are we going to manage any external communications and publications to ensure that information is shared appropriately and securely, right? So as we are, working with our clients to go through the due diligence when it comes to these agreements, is one, really making sure that our background IP is in place, right? And having an understanding of the other company's background IP, right? And then also the rights to the improvements that are generated through the background IP, right? If your partner, right, improves on your background IP, how are we going to handle that? Foreground IP, how are we going to handle the IP that is generated jointly? And then licensing and allocation, right? As this gets commercialized, how are we going to handle the licensing that goes along with that? Right. So licensing and usage rights. How are we going to handle the cross licensing and licenses, and then the rights to the foreground IP? Then also geographic limitations. Right. Let's say you are, the company that's developed their design and their small scale manufacturing product, right? How are we going to work with somebody in, let's say, Japan, right? So that's part of that also, right? And then confidentiality. This is really key, right? If we're, really working between large companies or even startups, right, where information and development is moving very quickly, how are we going to ensure that confidentiality is in place? And then as disputes may arise, right, how are we going to tailor the terms in that uh, collaboration agreement to ensure that this risk is reduced, and there's a clear path to dispute resolution. All right, so best practices, right? So it may be beneficial to avoid joint ownership, right? So you've collaborated, you've definitely, in this product development analogy, right? So you've mass produced this, you understand the product. There's a clear path to scaling this, right? So what are you going to do, right? So joint ownership, that might not be the best path forward if you want to, for example, be able to work with others. So it's really critical to understand your joint ownership rights. Also identifying the license scope, right? Is this going to be an exclusive license? Is this going to be a non-exclusive license? Right? What are the meets and boundaries of these licenses? And also a termination of rights, right? What's the term of this agreement? When do the rights in IP end? And then also, right, confidentiality, right? We need to ensure that confidentiality is in place not only during the agreement, but after the end of the agreement. Right. So key takeaways: make sure that we define ownership and usage, have clear licensing terms, protect confidential information, and resolve IP disputes early. So with that, we reserved the last 15 minutes for some Q&A.